I'm Justin Silverman of the New England First Amendment Coalition. Thank you all for joining us for this month's 30-minute skills lesson on how to avoid libel in news reporting. As a reminder, all of our classes are available to view at nefac.org/30-minute skills. There you'll find lessons on data visualization, web scraping, HIPAA and public records, self-care for journalists, and many other important topics. We have a lot to cover today and not a lot of time, so let's get started. Your instructor is Gregory V. Sullivan, General Counsel for the Union Leader in New Hampshire and a longtime board member of NEFAC. Greg, all yours.
And there we have the First Amendment. And whenever we're talking about defamation, I think it's important to keep the dictates of the First Amendment in mind. As we know, the First Amendment guarantees 5 basic freedoms to all U.S. citizens: religion, speech, press, assembly, and petition. And although it says Congress shall make no law, we now know that the First Amendment applies to all governmental action. And since 1925, all federal, state, and local officials are subject to the dictates of the First Amendment. So I saw this freedom of speech and I thought I'd exercise it because my friend was running for mayor of the city. And the incumbent mayor was a very nice woman, but I wanted her to lose. So I took out an ad in the paper a few days before the election saying, "Don't vote for the incumbent mayor. She's a child molester." Well, I found out the hard way that my speech is not always free. Found out that this lady could sue me successfully in court for defamation because I accused her of being a child molester, and it was totally false. So what is defamation? There are governmental interests that clash and crash head-on with our First Amendment rights. National security, public safety, protection and education of children come to mind readily, along with protection of reputation. There are others that we're not going to talk about today. We're going to focus on protection of reputation. And where do we get this right to enjoy a good reputation, that we can sue people and it will override their free speech rights if they make a false statement of fact that injures our reputation? I tried to figure out where we get that right. I can't find it in the First Amendment. I can't find it in the Bill of Rights. I can't find it in the Constitution. Turns out it comes from an ancient body of law known as the Ten Commandments. The 8th commandment says, "Thou shalt not bear false witness against thy neighbor." And from those ancient times to today, we get the law of defamation. There is a body of law called the Restatement of Torts. There's also restatement of other areas of the law. But the Restatement of Torts defines defamation as a false and defamatory statement of fact concerning another. Defamatory means injurious to reputation. An unprivileged publication to a third party, and we'll talk about privilege. Fault amounting to at least negligence on the part of the publisher. And this is a difficult one to say and swallow, but actionability means a successful lawsuit. Actionability of the statement, irrespective of special harm or the existence of special harm caused by the publication. And by the way, when I say publish, I mean speak, post, write to a third person. And we know that it's defamatory if it harms the reputation, lowers them in the estimation of the community, or deters third persons from associating with them. Thanks to Justin, I have this slide. Again, libel and slander. False, defamatory statement of alleged fact concerning a third party, communicated to a third party without defense. There are only 4 defenses to a defamation action. The biggest and best, of course, is truth. Secondly, we have privilege. The one we'll focus on today is called the reporter's privilege, or the fair report privilege. Opinion and hyperbole. Those are the only 4 defenses available to a defamation action. We'll start with hyperbole. The classic case of hyperbole was the Supreme Court of the United States overturned a state-issued verdict that Jerry Falwell got against Hustler magazine. Some of you may remember Jerry Falwell. He's passed away now, but he was an evangelical minister down in Virginia, very holier-than-thou kind of fellow, I think. And Hustler had been running ads for Campari, a liqueur. And the first one was, they played on sexual innuendo. Marilyn Monroe's first time was the headline. And then it would go on to say, first time Marilyn Monroe drank Campari was at the Beverly Hills Hotel. Well, Frank Sinatra's first time, the first time Frank Sinatra had Campari was in the backseat of a 1939 Ford. On and on, these ads with famous people, but the ad campaign ended. And Hustler thought they'd play a joke on Jerry. So basically, they said his first time having sex was in an outhouse with his mother during a drunken orgy. And it goes on and on. Wasn't it crowded in there? Not when I kicked a goat out. And says his mother had sex with everybody in town. On and on. It was so ridiculous, so over the top that the Supreme Court overturned the verdict, saying no reasonable person would believe this was a statement of alleged fact. There are 2 kinds of plaintiffs in a defamation action: the public plaintiff and the private plaintiff. And this was established in the landmark case of New York Times v. Sullivan in 1964. We'll look later on at the actual publication that Commissioner Sullivan, Lewis Sullivan, was the police commissioner in Montgomery, Alabama. And the Supreme Court, for the first time, decided these public officials and public figures, Madonna, Lady Gaga, Tom Brady, public figures, they must prove, if there is a false statement of alleged fact published about them, that the publisher knew that the statement was false, or at least acted with a reckless disregard for the truth. Court went on in later cases to define a reckless disregard for the truth, saying it's evidenced when the publisher publishes despite entertaining serious doubts about the truthfulness of the publication. It is a very high bar for a public plaintiff to meet. On the other hand, private figure who's defamed must only show that the publisher was negligent, i.e., failed to act as a reasonable publisher under the circumstances. Now, I talked a little earlier in the restatement about special harm. And again, special harm is a monetary loss or persons do not want to associate with you. Well, a plaintiff in a defamation action, if it's defamation per se, does not have to prove special harm and is still entitled to a monetary award of damages. So there are 4 categories of defamation per se. And if you are in a newsroom, if you are writing on your blog, or you're speaking to someone, and you're accusing someone of committing a criminal offense, or having a loathsome disease, a sexually transmitted venereal disease. I've been wondering whether COVID falls into that category, but never mind that. The third one is, to me, the most difficult, a matter incompatible with his business, trade, profession, or office. And you can go to the restatement of torts. These sections are amplified, and then there are cases underneath each section explaining them. And the last one, serious sexual misconduct. Not sexual misconduct, but serious sexual misconduct. Not really sure what that is. But this third one, and this is from the restatement, one who publishes a statement that ascribes to another conduct that would adversely affect their fitness for the proper conduct of their lawful business, trade, or profession, or of their office, is subject to liability without proof of harm. So if I say that lawyer can barely put 2 coherent sentences together is that defamation? And if it's not defamation per se, but there is special harm to the plaintiff, the defendant is liable to them. Now, we said earlier, one of the elements of defamation is a false statement of alleged fact. There is no such thing as a false opinion. The Supreme Court of the United States has made that abundantly clear. The mayor is a jerk. The mayor is an idiot. That's opinion. However, the restatement says, and the courts have held, that if the opinion implies the allegation of undisclosed defamatory facts as the basis for the opinion, then the publisher of that opinion may indeed be subject to liability. Very tricky, I think, and counterintuitive, undisclosed defamatory facts. I'll try to give you an example. Don't vote for the mayor. She is a bad alcoholic. Trust me, I've spent time with her every day for the past 60 years. She's got a bad booze problem. Well, that's my opinion, but I'm implying that I know things that you don't know, that I have undisclosed facts as the basis for my opinion. And if it's not true, I may be liable for that opinion, for publishing that opinion. Now, had I said, don't vote for the mayor, she's a bad alcoholic. Trust me, I've spent time with her every day for the past 60 years. And on the third Thursday of every month at 4 o'clock in the afternoon, she drinks a half a glass of beer. I don't think she drinks other than that, but boy, she's a bad alcoholic. Now I've given you the opinion, but I've given you the facts that underlie that opinion, and therefore I cannot be held liable because the listener, the recipients of that publication, are free to say, wait a minute, that lawyer's the idiot, and the mayor's not an alcoholic. She barely drinks at all. Very key, and that's why I put it in red. I have gotten over the years quite a bit in newsrooms, somebody saying, well, we're going to publish this because it was published earlier in the Boston Globe or the New York Times. One who repeats or republishes defamation is just as subject to liability as if he or she they had originally published it. There is a reliable source defense that is not as widespread as it used to be when we only had the wire services of AP and UPI, but there is such a defense which you can claim in front of a jury. We only published this because it was in the New York Times and we trusted them as a reliable source, but you don't want to do that. If you're going to publish something that raised a red flag in your mind when you went to publish, then double, triple check the facts and your sources. We do have the fair report privilege, but it's very limited. And this is what it says: the publication of defamation concerning a third person in a report of an official action or proceeding or of a meeting open to the public that deals with a matter of public concern is privileged, so long as that report is accurate, or at least a fair abridgment of what happened. Someone gets up at a city council meeting and accuses someone of a crime, and it's false and it's defamation. We are free to republish that, respeak it, put it in the newspaper, as long as it's accurate. The police chief calls a press conference, says we have an outstanding warrant on John Smith. He's wanted for distribution of narcotics. It turns out the chief meant to say John Jones. He's defamed John Smith, but we can publish that because it was at a press conference. Now, if the mayor says it to a reporter Saturday morning at the diner over breakfast, and we publish it, the publisher is going to be liable because we don't have that fair report privilege because it wasn't at an official action. such as a press conference. Interestingly enough, we can defame products, companies or individuals that produce products, if it's going to damage that individual or company. A couple of classic cases that have always concerned me. One, Bose Radio sued a publication because the publication said that Bose Radio was no good. The sound bounces off the walls. It's hard to hear. It was a terrible report. And Bose sued unsuccessfully because there was an opinion defense. Same thing with Rain-X. There was a publication that said Rain-X doesn't work. It makes the windshield worse when you're driving in the rain, which I thought was very false, but held to be an opinion. But you can be guilty of defamation relative to products. Corporation, profit or nonprofit. If we say something that's false and injurious, corporation can recover just like an individual. Partnerships, unincorporated associations, same thing. Now, groups. The group, an individual who's in the group has to be identifiable because the group is so small. If I say all Boston cops are on the take and corrupt, no individual Boston cop is going to be able to sue me successfully because the number of individuals in that group is so large. But if I'm talking about Little Town, USA, where there's only 3 police officers, and I say all Little Town police officers are corrupt and on the take, each one of those individual officers would have a successful defamation action unless what was published was true. They were on the take. So this is the publication that led to the case of New York Times versus Sullivan. Louis Sullivan, the police commissioner, had received a verdict in Alabama that was affirmed by the Supreme Court of Alabama. And the Supreme Court of the United States, as I said earlier, went to great lengths to distinguish public plaintiffs versus private plaintiffs. But in reality, the reason Commissioner Sullivan lost his case because the court said this publication was not of and concerning him. He was not readily identifiable. It talked about the police doing things that, and actually there were a number of false allegations in the ad relative to the police conduct, but it was not of and concerning Commissioner Sullivan. We had a case recently in New York where the New York Times was successful in defending a defamation action by a woman from Alaska named Palin. And because she's a public figure, had been the governor of Alaska and had run for some other public office, unfortunately, she did not meet, according to the judge, the actual malice standard. Again, she had to prove that the New York Times knew that it was false when it said, and you'll see it down there in the corner, when it said there was a link between shootings and murder and Sarah Palin's political action committee. Indeed, her committee had circulated a map targeting districts that, including Gabby Gifford's representative, with targeted crosshairs over each district, and Gifford's district was one of them. But there was no link between that shooting and Sarah Palin's. There was no evidence that the shooter had ever seen or knew anything about this map that was circulated by Palin's committee. That case probably is going to be appealed, although the judge let the jury come back with their verdict after he announced, not to the jury, that he was going to dismiss the case. So that is weakening her ability to have a successful appeal. But there are two justices on the Supreme Court of the United States who want to do away with this actual malice standard. In that, I've underlined what Palin was complaining about. The link to political incitement was clear. Before the shooting, Palin's committee distributed this map. This is, and I don't know if we have time, I should have emailed everybody this. This is a case where a food critic came to a new restaurant, a Cajun restaurant being opened in Boston. And the publication said these people couldn't run a hot dog stand. They were, by the way, very successful restaurateurs. The food, taint Cajun, taint Creole, taint French, taint nothing but putrid. The supposed beef was actually all fake food, ground up schmutz. Stay away from the place unless you enjoyed being greeted by a bitch hostess and eating nasty animal scraps. Quite a review. And for some reason, the restaurateurs took exception and sued for defamation. So I'd like to hear from you all as to whether or not the Beacon Hill Bugle and its reporter committed defamation against the restaurateurs, because that's the end of my time. And I want to take as many questions as we can, but if you want to jot this down, I'd be glad to receive communications via email, questions, thoughts, comments.
I've got a few questions lined up and we'll get to them in the time remaining. The first one goes back to the Palin case, the actual malice standard, and the idea of a public official, a public person. As one person writes, we have this rise of people on social media and blogs, high profile, very public individuals. How do we determine who's a public figure and who's a private figure? What are some of the primary considerations to make?
Well, probably the most primary consideration is whether or not the individual has thrust themselves into the vortex of a public controversy. Some people are public figures for all purposes. Public official is easy: president, governor, mayor, etc. Public figures, some are public figures for all purposes. One that comes to mind is that fellow Trump, who used to be the president of the United States. He's a public figure for all purposes. The more difficult task is determining when someone thrusts themselves sufficiently into a controversy that they become a public figure. It's important to remember that the publisher cannot create the public figure. They can pick on an individual and write about them repeatedly, but if the person has not sought the public spotlight, has not injected themselves into a debate on a matter of public concern, then they're a private figure.
Thank you. Another question here of particular importance for many of the journalists that are joining us today. The fair report privilege. I know you mentioned it earlier on, but can you talk about that a little bit more and maybe explain in more simple terms what this privilege is and when it applies?
Sure. I mean, it's important to note that it only applies if we are reporting on a public action taken by a government official or someone participating in, for example, a town meeting, city council hearing, testimony before the legislature, press conferences called by a mayor or a chief of police. It has to be reporting on an official public action or meeting, period. Not something the police chief tells you one-on-one or 1-on-35, unless it's an officially called press conference. Press release, for example, by a police department. We had a case recently where the police department issued a press release saying there are 16 people that are wanted for distribution of drugs, and they not only listed their names, they provided pictures of the individuals, and it was published on television and in a number of newspapers, online and print. And one of the individuals named by the police release indeed was not the subject of a search for being guilty of distributing drugs. In fact, he was in jail at the time and sued. But because it was republished from an official government release, the fair report privilege applied, and the media defendants were able to get the case dismissed.
Thank you. I have another question here specific for reporters. What good practices would you suggest reporters take to protect themselves from libel? So, for example, a reporter finds themselves being accused of libel. They come to you for counsel. You know, what is the first thing you would ask from them? Would you ask for their notes, you know, from the past X years or other materials? You know, what can reporters do as far as their news gathering and the way that they, you know, maintain all the materials that they gather to help defend themselves against libel claims?
But I get a lot of inquiries early on in the process, during the reporting, prior to the publication. And one of the first questions I usually ask is, well, did you get the other side of the story? Did you track down the person who's being written about? Which is not always easy to do, but you at least may put in your story attempts to locate and communicate with the subject of the story were of no avail. But yeah, you got to get both sides of the story, particularly when you're talking about those defamation per se categories, someone being accused of a crime, etc. Get their side of the story. And, you know, legwork is huge. Of course, now a lot of our legwork is done electronically, thank goodness. But if you're going to write about a court case, look at the actual documents on file in court. Don't take somebody's word for what they say. So, you know, check your sources, recheck your sources, recheck your facts. You want to make sure that what you're publishing is the truth.
Thank you again, Greg. And I want to thank everybody else for joining us today. Again, if you found today's lesson helpful in any way, I want to encourage you to make a donation at nfac.org. These lessons that we provide every month are a free public service by our coalition. We depend on your support to offer them, along with the many other First Amendment programs that we offer throughout the year. We're also looking for suggestions on future topics. So if there's a 30-minute skill that you're looking to learn, let us know by emailing me directly at justin@nfac.org. Many thanks again to all of you. I'll see you back here next month for our next 30-minute skills.
Can I say one thing?
Absolutely. Go ahead.
I wanted to get people's opinion on the fact pattern I put up about the Cajun food. So if anybody wants to email me, I'll be glad to email you that particular fact pattern and we can talk about it, because I'm interested in what people think about that case.
Excellent. I would encourage everybody to do so. Thank you again, Greg. Appreciate your help today.
Thank you, Justin. Thanks, everybody.